You know, most inventors find out way too late that their patent application has gaps, usually right after it's been rejected. But what if your attorney had been that examiner? What if the person writing your application used to be the one deciding what got approved? Let's talk about that.
It all starts with a really deep understanding of the system. We're talking over 15 years of combined experience, not just as a patent attorney, but also from inside the U.S. Patent and Trademark Office.
And look, that kind of inside knowledge, it gets results. We're talking over 500 patents successfully filed and prosecuted for inventors just like you. But this is the number that really makes you stop and think. A 95% success rate in getting patents approved. So you gotta ask, how is that even possible?
Well, to get that, you first need to understand a problem that trips up almost everyone. We call it the application gap.
It's the question every inventor dreads. You've poured your heart and soul into your invention, you file the application, you wait, and then you get a rejection. Why on earth does this happen so often?
The answer, honestly, is pretty simple. Most applications have these hidden gaps. Now, you might not see them, but to a trained USPTO examiner, they pop right off the page. It's literally their job to find them. And this right here really breaks down why that happens. See, as the inventor, you're focused on the features, on what makes your creation so unique and cool. You assume its value is obvious. But the examiner? They're playing a different game. They're focused on the legal strength of the claims, looking for any overlaps with existing patents, and they need incredibly precise language to prove it's new. It's like you're speaking two totally different languages. So the key, the real game changer, is bridging that gap. The solution isn't to just wait and react to rejections. It's to start thinking like an examiner from day one.
Think about it this way. The standard approach is reactive. You file, you get a rejection, and then you try to fix it. The approach we're talking about is completely proactive. It's about anticipating every single potential rejection and building an application that's basically immune to them from the start.
And this is the fundamental reason why that's even possible. It's because we know what examiners approve, because we were examiners.
We call this examiner's logic. And listen, this isn't just about having experience. This is about having access to the internal playbook, the reasoning used inside the USPTO. That knowledge completely changes how a patent is drafted, letting you sidestep all the common traps before they ever become a problem.
Okay, so what does this actually look like for you? Well, no matter where you're at with your innovation, there's a clear path forward. This isn't just some list of services, it's a roadmap. So if you've got a new idea, you're probably looking at a provisional or non-provisional application. If your application's already been rejected, then we're talking about patent prosecution. Maybe you have an existing patent but found a mistake in it. That's what reissue and reexamination are for. And of course, protecting your brand, that's trademark registration.
So, let's circle back to that 95% number. It's not magic. It's the direct result of this whole proactive, examiner-focused way of doing things.
See that lower bar? That's the typical reality, where getting rejected the first time is pretty common. That much higher bar, well, that's what happens when your strategy is designed to avoid that first rejection altogether. Seriously, it's almost an expectation in the industry that your application will get rejected at least once. So a 95% approval rate tells you a story. It tells you everything about the strategy and foresight that goes into building the application before an examiner ever lays eyes on it. It was built to be approved.
So how do you get this kind of insight, this direct line for your own invention?
Being located right in Washington, D.C. is a huge plus. It's more than an address. It's a strategic advantage. It means you're at the very heart of the U.S. patent system, which gives you direct insight and access, whether you're here in the States or an international client.
The next step is really simple. You can book a consultation at ipboutiquelaw.com to talk through your situation. No pressure at all. Or you can just call directly. And it's important to know we can help you in both English and Spanish.
We'll just leave you with this one question to think about. The issue is rarely about whether your invention is good enough. The real question is your application built to be approved?